Hello, everyone, and welcome back to When Algorithms Govern, the podcast where we explore what happens when artificial intelligence moves beyond recommendation systems and chatbots and starts influencing decisions about people's rights, benefits, duties, and opportunities. I'm Emma.
And I'm Daniel. Today we are discussing a difficult but extremely important question. What happens when governments automate decisions that traditionally required human judgment?
For example, a decision about whether someone qualifies for unemployment benefits.
Exactly. Or whether a person should receive housing support, whether a tax return should be investigated, whether a visa application should be approved, whether a family needs social assistance, or whether a person should be placed in a high-risk category.
At first sight, automation sounds attractive. Computers can process applications faster, apply the same rules to everyone, and reduce administrative costs.
That is the optimistic view. But today's chapter introduces a deeper problem. Public decisions are not always a matter of simply applying a fixed rule to a fixed set of facts. Sometimes the law requires judgment. Sometimes it requires an exception. Sometimes it requires the decision maker to compare the government's goal with the burden imposed on an individual. That process is closely connected to two legal ideas: discretion and proportionality.
So our three main concepts are discretion, automation, and proportionality.
Yes, and the central question is, can a public authority automate decision-making while still preserving the contextual judgment required by proportionality?
Part 1. From street-level bureaucracy to system-level bureaucracy. Let's begin with discretion. What does administrative discretion mean?
Administrative discretion means that a public official has some legally permitted space to choose between different possible actions or decisions. The law may define the goal and the outer limits, but it may not prescribe one automatic answer for every possible situation.
Can you give us a simple example?
Imagine a local authority provides emergency housing support. The law says assistance may be granted when a person faces serious hardship. But what counts as serious hardship? A person whose heating system has failed during a mild week in may be in a difficult situation. A person whose heating system has failed during a freezing January night may face an immediate health risk. The same general rule applies, but the circumstances are different.
So the official has to interpret the facts, understand the context, and decide what the rule requires in that particular case.
Correct. Discretion allows the official to move from an abstract legal rule to a fair and lawful individual decision.
But discretion can also be dangerous, can't it?
Absolutely. Human decision makers may be inconsistent. Two officials may treat similar people differently. Officials may be influenced by stereotypes, emotions, fatigue, institutional pressure, or personal prejudice. Discretion may slow down administration and make outcomes less predictable.
That sounds like a strong argument for automation.
It is one of the strongest arguments. If the same verified facts are entered into the same automated system, the system should normally produce the same output. That can improve consistency and predictability.
And potentially reduce certain kinds of human bias.
Potentially, but we should be careful. Automation does not eliminate judgment. It often relocates judgment.
What do you mean by relocates?
Suppose a human official previously considered 10 different aspects of an applicant's situation. An automated system may be designed to consider only 5 variables. Someone decided which 5 variables mattered. Someone decided how they should be measured. Someone decided what threshold would trigger approval or rejection. Someone decided how missing data should be handled. Those are judgment calls.
So discretion may move from the caseworker to the programmer, data scientist, procurement team, or system designer.
Exactly. This is sometimes described as a shift from street-level bureaucracy to screen-level bureaucracy, and eventually to system-level bureaucracy.
Let's unpack those expressions.
A street-level bureaucracy is a public employee who interacts directly with citizens and applies general rules to real-life situations. Think of a social worker, police officer, immigration official, teacher, benefits officer, or public health administrator. In screen-level bureaucracy, the official increasingly interacts with the citizen through digital forms, databases, and decision support tools. At the system level, important parts of the decision may be determined by the design and operation of the technical system itself.
So instead of asking, what did the caseworker decide, we may need to ask, what was the system designed to recognize?
Exactly.
Let's use a concrete example. A city introduces an automated system for housing benefits. Applicants enter their income, rent, family size, employment status, and savings. The system calculates eligibility. What has changed?
The city has standardized the process. That may be beneficial for straightforward cases. But suppose an applicant recently escaped domestic violence and cannot provide some of the documents normally required. A human official may understand that demanding those documents immediately is unreasonable or dangerous. A rigid system may simply say documentation incomplete, application rejected.
The system is consistent, but possibly unfair.
Yes. consistency and fairness are not always the same thing. Treating everyone identically may be unfair when people's relevant circumstances are different.
Part 2. The protective and dangerous sides of discretion.
It sounds as though discretion has two faces.
That is a good way to put it. Discretion can produce arbitrariness, inconsistency, and bias, but it can also protect people from the unreasonable consequences of rigid rules. Could we say discretion is both a risk and a safeguard?
Precisely. Consider a school attendance rule. Suppose parents are fined automatically when a child misses more than 10 days of school. For many cases, that rule may identify genuine attendance problems. But imagine a child undergoing cancer treatment. An automated system sees 12 absences and issues a fine. A human decision-maker sees the medical context and recognizes that punishment would be inappropriate.
So discretion allows the authority to correct an unreasonable result.
Yes, it can add what we might call a touch of humanity to the application of law. But this creates a legal design dilemma.
Which is?
How do we preserve enough discretion to deal with exceptional circumstances while limiting enough discretion to prevent arbitrary or discriminatory decisions?
That seems to be where proportionality enters the picture.
Exactly. Proportionality helps structure the exercise of public power. It does not simply say, use your intuition. It asks the authority to justify the relationship between its objective and the measures it uses.
Part 3. What is proportionality? The word proportionality appears everywhere in European law, but it can sound abstract. How would you explain it to someone with no legal background?
At its core, proportionality means that the government should not use a more restrictive or harmful measure than is justified by its legitimate objective. The means must have a reasonable relationship to the ends.
For example, using a national surveillance system to find someone who failed to return a library book would be disproportionate.
Exactly. The government may have a legitimate interest in recovering public property, but the measure would be far too intrusive for the seriousness of the problem.
How is proportionality usually tested?
Although legal systems formulate the test in slightly different ways, it commonly includes 4 questions. First, is there a legitimate aim? Second, is the measure suitable for achieving that aim? Third, is the measure necessary, meaning that no equally effective but less restrictive alternative is reasonably available? Fourth, does the measure strike a fair balance between the public objective and the harm imposed on individual rights or interests?
Let's apply those 4 questions to an example. Suppose a university wants to prevent cheating during online examinations. It introduces remote proctoring software that records students' faces, rooms, screens, voices, eye movements, and keyboard activity. What is the legitimate aim? Protecting academic integrity and preventing cheating. Is the technology suitable? Possibly. It may help identify certain forms of suspicious behavior, but suitability requires evidence. The university should not merely assume that the system works. It should ask whether the system actually helps achieve the stated objective. Next comes necessity. Correct. The university must ask whether it could achieve a comparable level of exam integrity through less intrusive means. Could it redesign the examination? Could it use open book questions? Could it conduct short oral follow-ups? Could it record only the screen rather than the student's entire room? And the final balancing stage asks whether the overall benefit justifies the impact on privacy, dignity, equality, and possibly accessibility.
Exactly. A system might be somewhat effective and still impose excessive costs on students' rights. For example, students may live in shared homes, have disabilities affecting eye movement, or lack a private room. The system might falsely classify normal behavior as suspicious.
So proportionality is not merely a technical efficiency calculation.
No, it is a legal and normative evaluation of power, purpose, rights, circumstances, and consequences.
Part 4. The many faces of proportionality. The chapter suggests that there is not just one simple proportionality rule.
Correct. Proportionality appears across several areas of European law, including human rights law, EU law, constitutional law, administrative law, and data protection law. These versions share a common core, but may operate differently.
What changes from one legal field to another?
Several things. What must be proportionate may change. Who is responsible for ensuring proportionality may change. The moment at which proportionality must be assessed may change, and the legal consequences of disproportionality may change.
Let's begin with human rights law.
In human rights law, proportionality is often used to determine whether government interference with a protected right is justified. For example, the government may restrict privacy, expression, movement, or property rights under certain conditions. But the restriction normally needs a lawful basis, a legitimate objective, and a proportionate relationship to that objective.
What about constitutional law?
At the constitutional level, proportionality may limit the legislature, the executive, administrative authorities, and courts. A parliament cannot simply pass any measure it wants because it has political support. A measure that excessively interferes with constitutional rights may be invalid or unconstitutional.
Administrative proportionality sounds more focused on individual public decisions.
Often, yes. Administrative authorities exercise powers granted by legislation. Even when an official has formal legal authority, the way that authority is used may still be disproportionate.
Give us an example.
Suppose a restaurant fails to display one required notice. The authority may have several legally available options: issue a warning, impose a small fine, temporarily suspend the license, or permanently close the restaurant. If the omission is minor and immediately corrected, permanently closing the restaurant would likely be disproportionate.
Even if closure is technically listed among the authority's powers?
Yes, formal legal authority does not automatically make every use of that authority lawful. Legality and proportionality are related but distinct.
That is an important distinction.
Very important. A decision may have a formal legal basis and still violate the law because it is disproportionate.
And data protection law?
Data protection law contains many requirements that can be understood as context-specific expressions of proportionality. Consider data minimization. An organization should process personal data that is adequate, relevant, and limited to what is necessary for the purpose. That is a proportionality idea.
Do not collect everything merely because it might be useful one day.
Exactly. Security measures also need to be appropriate to the risk. Data sharing needs justification. Retention periods should correspond to legitimate needs. These are all ways of balancing organizational purposes against the rights and interests of individuals.
Part 5. Proportionality beyond obvious rights cases. Many people associate proportionality with dramatic constitutional disputes: national security, freedom of expression, police powers, and so on. But the chapter says it also matters in ordinary administrative life.
Yes, proportionality may be relevant in everyday interactions between citizens and public authorities. This is particularly important because automation is often introduced in ordinary high-volume services,
such as Social Security, taxation, healthcare administration, student finance, and immigration processing.
Correct. Let's imagine a public employment agency. A person receiving unemployment assistance must attend regular appointments. The system automatically suspends benefits when someone misses an appointment. That seems straightforward.
Until we learn that the person was in hospital.
Exactly. Or perhaps the appointment notice was sent to an inaccessible digital mailbox, or the person has a cognitive disability, or the agency itself recorded the wrong date. The question is not merely whether the person missed the appointment. The question is whether suspending the person's entire income is a lawful and proportionate response under the circumstances.
So even an apparently routine decision can affect dignity, property, family life, health, or access to basic necessities.
Yes, socioeconomic administration may interact with fundamental rights in very direct ways. And because automated decision-making generally involves personal data, privacy and data protection requirements are also frequently activated.
Algorithmic discrimination introduces another layer.
Indeed, if a model produces systematically different outcomes for different groups, the authority may need to determine whether that difference is objectively justified and proportionate.
Let's make that concrete. A fraud detection system assigns higher risk scores to people living in certain neighborhoods because historical data shows more investigations in those areas. What is the problem?
The historical pattern may reflect earlier enforcement choices rather than actual fraud rates. Perhaps those neighborhoods were investigated more frequently because of institutional bias. The model then treats the resulting investigation data as objective evidence.
So past scrutiny creates the data that justifies future scrutiny.
Exactly. That is a feedback loop. The system may disproportionately burden already disadvantaged communities while appearing statistically neutral.
Part 7. Proportionality is not mathematical.
Now we reach the technical heart of the discussion. Could we simply program the proportionality test into an AI system? Parts of it may be supported by technology, but fully automating proportionality is extremely difficult.
Why?
Because proportionality is not merely a sequence of mathematical calculations. It depends on context, legal interpretation, social values, evidence, communication, and judgment.
But some proportionality theories use balancing formulas. Couldn't we assign numbers to the importance of the government's goal and the severity of interference?
That creates an appearance of precision. But what would the numbers mean? How many units of privacy equal 1 unit of public safety? How do we compare dignity with administrative efficiency? How do we measure the anxiety caused by surveillance? How do we quantify the effect of losing housing support on a family with a disabled child?
The values may be comparable in legal reasoning without being measurable on one common numerical scale.
Exactly. One philosophical objection is known as incommensurability. The things being balanced may be so different that they cannot be measured using the same unit. It is like asking whether an elephant weighs more than the color blue.
That comparison is absurd because weight and color are different categories.
Yes, legal interests are not always that radically different, but the analogy demonstrates the problem. Proportionality uses the language of balance, weight, and measurement.
Yet the actual reasoning is often deliberative rather than mathematical.
What does deliberative mean here?
It means the decision maker must explain the relevant interests, examine the evidence, consider alternatives, understand the practical consequences, and justify why one course of action is reasonable in the legal context.
So proportionality structures judgment without eliminating judgment.
That is an excellent formulation. It reduces arbitrariness by requiring a reasoned analysis, but it does not guarantee that every reasonable person will reach the same answer.
That sounds uncomfortable for engineers.
It can be. Engineering often seeks stable inputs, formal rules, and reproducible outputs. Law sometimes contains those things, but it also contains open-ended concepts such as reasonable, appropriate, necessary, excessive, undue hardship, best interests, relevant circumstances, and fair balance.
Those terms are not defects in the law.
Exactly. They sometimes exist because society wants the law to remain sensitive to context.
Part 7. Correlation versus legal interpretation. The chapter also raises concerns about using statistical correlations as the basis for legal decisions.
Yes, machine learning systems frequently identify patterns in historical data. They may predict that people with certain characteristics are more likely to miss payments, commit fraud, require medical treatment, or fail to comply with administrative duties.
Why is that different from legal judgment?
A prediction answers a question such as, which individuals resemble previous cases associated with this outcome? A legal judgment asks, what reasons recognized by law justify treating this individual in a particular way? Those questions can overlap, but they are not the same.
Can you give us an example?
Imagine that historical data shows that applicants who change addresses frequently are statistically more likely to submit incomplete welfare applications. A predictive system might use address changes as a risk factor, but an individual may have changed addresses because they were homeless, escaping abuse, or moving between temporary accommodations.
So the correlation exists, but its legal meaning is unclear.
Correct. The system may accurately identify a statistical pattern while producing an unjustified legal inference.
And correlations can change.
Yes, social correlations are fragile. They may change over time, across regions, or because people react to the existence of the system.
For instance, when people learn which behavior triggers a fraud alert, then they change their behavior.
Exactly. The system changes the environment it is measuring. There is also the question of which correlations designers choose to consider significant. Data does not walk into the system and explain itself. Human actors select targets, labels, features, thresholds, and evaluation criteria.
Part 8. Discretion and proportionality are connected but different. We have been using discretion and proportionality together. Are they basically the same thing?
No, they are connected but legally distinct. Discretion gives the decision maker room to consider context or choose between lawful alternatives. Proportionality requires certain contextual considerations and places limits on the result.
So discretion permits judgment, while proportionality disciplines judgment.
Exactly. Another way to express it is this. Discretion may begin where detailed legal rules end. Proportionality is itself part of the law.
Could proportionality sometimes increase discretion?
Yes, interestingly. Suppose a rigid general rule would produce an excessive result in an exceptional case. Proportionality may require the official to make an exception. That expands the official's practical space to depart from the ordinary rule.
But proportionality also limits the available options.
Correct. Return to our benefits example. Suppose the authority may impose one of 3 conditions on a recipient: attend one job search workshop, attend a weekly workshop for 3 months, or complete unpaid work every day for 3 months. All 3 options may be legally available in general, but for a single parent caring for a disabled child, the third option may be disproportionate. If the first option achieves the same legitimate purpose with less burden, necessity points toward the first.
So discretion gives the authority 3 choices. Proportionality may remove 1 or 2 of those choices in the specific case.
Precisely.
What happens when 2 alternatives are equally effective and equally restrictive?
Then there may still be a space for discretion. Legal scholars sometimes distinguish between structural discretion and epistemic discretion.
Let's explain both.
Structural discretion exists when proportionality neither requires nor prohibits one particular choice. For example, 2 measures may be equally effective and equally intrusive. The law may leave the final selection to political or administrative judgment. Epistemic discretion arises from uncertainty about facts or values.
For example, uncertainty about whether a measure will actually reduce fraud.
That would be empirical uncertainty. Normative uncertainty arises when it is unclear how 2 competing rights or principles should be balanced.
So even proportionality contains some discretionary space.
Yes, that makes the idea of fully automated machine proportionality even more challenging. Part 9. Could machines exercise discretion?
Let's ask the futuristic question. Could a sufficiently advanced AI exercise genuine discretion?
It depends on what we mean by discretion. A system can select between options. It can optimize goals. It can process contextual variables. It can generate explanations. But legal discretion is not merely computational choice. It involves authority, responsibility, justification, interpretation, institutional role, and accountability.
So suppose a language model reads the law, the case file, previous court judgments, medical information, and the applicant's explanation. It then recommends the least restrictive measure. Would that count as machine discretion?
It may imitate parts of discretionary reasoning, but important questions remain. Does the model understand which facts are legally relevant? Can it recognize a genuinely new type of hardship not represented in its training data? Can it explain its reasoning in a stable and legally reviewable form? Who is responsible when it makes an error? Can the affected person challenge the assumptions? Can the system revise its judgment through dialogue?
And is it following law or merely generating text that resembles legal reasoning?
Exactly. We should not confuse linguistic fluency with legal authority or reliable judgment. So the chapter does not claim that machine proportionality is impossible forever. No, the more careful position is that complex general machine proportionality has not been achieved and remains elusive. Current systems can support parts of the process, but relying on them to identify every context requiring an exception would be unsafe. Part 10. The 4 stages of proportionality. Now let's examine the chapter's central analytical framework. It identifies 4 stages at which proportionality can be assessed and protected. Right. The legislative stage, the system implementation stage, the decision stage, and the ex post stage. Why is this 4-stage structure important? Because people often discuss automated decision-making as though proportionality matters only when the final decision reaches the citizen. In reality, choices made much earlier may already determine whether proportionate outcomes are possible. Part 11. Stage 1. Legislative proportionality. Let's begin with the legislative stage. At this stage, lawmakers design the legal framework. They identify public objectives, define powers, establish conditions, and decide how competing interests should generally be balanced. This happens before any individual case exists. Exactly. The assessment is in abstracto, meaning in general or in the abstract. The legislature asks questions such as, what problem are we trying to solve? Is government intervention justified? May decisions be automated? Which data may be used? What safeguards are required? Which cases require human review? What rights of explanation, correction, or appeal should exist? Could you give us a legislative automation example? Imagine a country wants to identify fraudulent claims for childcare benefits. The legislature authorizes an automated risk assessment system. At the legislative stage, lawmakers should examine not only the efficiency benefits, but also the possible collective effects. Will large groups be placed under surveillance? Will sensitive personal data be processed? Could the system disproportionately target migrants or low-income families? Is the legal mandate sufficiently clear? Are there strict limits on how the risk scores may be used? So the legislature conducts a kind of blanket proportionality assessment. Yes, it establishes general rules for a large category of cases. What is the advantage of doing this early? It can prevent disproportionate decisions at scale. For example, legislation can prohibit the use of ethnicity as a risk factor, limit data retention, require independent audits, or ban automatic sanctions based solely on risk scores. But blanket rules cannot foresee everything. That is the central limitation. Lawmakers reason in general categories. They cannot know every future combination of facts. A rule may be proportionate for 99% of cases and still produce a severely disproportionate result in the remaining 1%. That 1% is what lawyers sometimes call the hard cases. Yes, rare, unforeseen, complex, or exceptional cases. Could lawmakers solve the problem by writing excessively detailed rules? They can reduce uncertainty, but excessive detail creates new problems. The law may become rigid, complicated, and quickly outdated. The more lawmakers attempt to predict every possible situation, the greater the risk that genuinely new circumstances will fall outside the categories. So legislative precision helps automation, but may reduce adaptability. Exactly. That is a recurring tension. Automation prefers precise, structured, machine-readable rules. Justice sometimes requires open-ended, contextual standards. Part 12. Legislative safeguards and systemic risks. What kinds of safeguards should legislature include when automated processing is involved? Depending on the context, legislation may need to specify the legitimate purposes of the system, categories of data that may be processed, prohibited data or inferences, decision thresholds, retention periods, access controls, transparency obligations, human review requirements, appeal procedures, audit duties, and conditions for suspending the system. Why is clarity especially important with automated systems? Because automation can apply one legally flawed rule thousands or millions of times.
A human official's error may affect one case. A system design error may affect an entire population. Scale magnifies both efficiency and harm. Exactly. Let's imagine a tax authority uses an automated model to identify high-risk returns. If the legislature says only, the authority may use any relevant information to detect risk, what is wrong with that? The mandate may be too broad. It leaves major questions unanswered. Can the authority use social media data, location history, family members' financial information, nationality, health records, consumer purchases? Without clear limitations and safeguards, the authority may gain excessive power, and a lack of transparency can make the system difficult to challenge. Yes, affected people need some way to understand what has happened and to contest errors or unlawful assumptions.
Part 13, Stage 2, System Implementation Proportionality. Let's move to the second stage, System Implementation.
This is where legal mandates are translated into technical and organizational systems. Public authorities decide what software to use, what data to collect, how to structure workflows, what the model should predict, and when humans should intervene.
This is where law becomes architecture.
Beautifully put. A legal rule may appear balanced on paper, but implementation choices can change its practical meaning.
Can you give an example?
Suppose the law says a benefits authority may investigate applications when there are reasonable grounds to suspect fraud. A system designer needs to translate reasonable grounds into operational criteria. Perhaps the model treats the following as risk factors: frequent address changes, inconsistent income records, joint bank accounts, foreign telephone numbers, and missing documents. Each proxy embeds assumptions.
A foreign telephone number might simply mean someone has family abroad.
Exactly. Frequent address changes may indicate housing insecurity, not dishonesty. When designers translate legal standards into features and thresholds, they may unintentionally narrow or distort the law.
So programmers can occupy discretionary space that the legislature intended for legally trained officials.
That is a major concern. Where the law leaves discretion to public decision makers, system designers should not silently resolve that discretion through code without proper legal authorization and accountability.
In other words, a software requirement should not become hidden legislation.
Exactly.
Part 14. Data protection as system-level proportionality. Why is data protection particularly important at the implementation stage?
Because automated systems depend on data, often personal data. System-level proportionality requires asking, do we genuinely need each data category? Is the data sufficiently accurate? How long should it be retained? Who can access it? Can less sensitive data achieve the same purpose? Are security measures proportionate to the risk? Is data being repurposed beyond the original justification?
Let's consider a public health system predicting which patients may miss appointments. It could use appointment history and travel distance. Would it also need access to complete tax records, social media activity, and relatives' medical histories? Probably not, unless the authority could establish a very strong and lawful necessity. The fact that a variable improves predictive accuracy by a small amount does not automatically justify processing it. That is an important lesson for engineers. More accurate does not always mean more lawful.
Correct. A model that is 92% accurate but requires invasive surveillance may be less legally acceptable than a model that is 89% accurate and uses minimal data.
This is a direct application of necessity. Is there a less intrusive way to achieve a sufficiently similar result?
Exactly.
Part 15. Identifying hard cases. The chapter emphasizes that systems should identify hard cases and transfer them to humans. How could that work in practice? A system could be designed with escalation rules. For example, a case must be transferred to a human when required data is missing or contradictory, the person presents exceptional circumstances, the decision would significantly restrict a right, the confidence score is low, the data falls outside the training distribution, protected characteristics may be indirectly implicated, the individual disputes a key fact, or the proposed measure is unusually severe. So the system does not need to solve every difficult problem. It needs to recognize when it may not be competent to solve the problem.
Precisely. That is a form of institutional humility.
But even uncertainty detection can be difficult.
Yes, a system may be very confident and still wrong. Confidence in a statistical prediction is not the same as confidence in the legal appropriateness of the decision.
Could we use a two-layer system? The model processes routine cases, but cases with significant legal consequences are automatically reviewed by a human.
That may be sensible, but we need to examine the quality of the human review. Merely routing a case to a person does not guarantee meaningful oversight.
Part 16. Stage 3. Decision-level proportionality. Now we reach the individual decision. At the decision stage, proportionality must be considered in casu, in the particular case.
The authority examines the actual person, facts, consequences, and available alternatives. Let's build a detailed example. A person receives disability support. An automated system detects that the person failed to submit an annual document by the deadline. It recommends immediately suspending payments. What should happen? A purely rule-based process might say, deadline missed, legal condition not satisfied, payment suspended. A proportionality-sensitive process asks additional questions. Was the person properly informed? Was the notice accessible? Does the person have a cognitive or physical impairment affecting compliance? Was the delay minor? Is the missing document essential? Could the authority request the document again? Would suspension threaten the person's housing, food, medication, or care? Is a warning or temporary extension sufficient? The legitimate aim may be ensuring that only eligible people receive support. Yes, suspension may be suitable in some cases, but it may not be necessary if a reminder and short extension would achieve the same purpose. And even if temporary suspension is normally justified, the severe effect on a particularly vulnerable person may make immediate suspension disproportionate. So an apparently simple compliance decision becomes a contextual legal assessment. Exactly. Part 17. Historical data and new circumstances. Why are current machine learning systems particularly challenged at the decision stage? Because they generally learn from historical data and apply those patterns to new cases, but new circumstances may emerge that are not represented in the historical data. For example, a pandemic. Yes. Imagine a model trained to assess self-employed workers before a pandemic. Suddenly, many people experience unusual income patterns, interrupted contracts, emergency support payments, and business closures. The old correlations may no longer be reliable. Or a war leads to large numbers of displaced applicants with incomplete documentation. Exactly. The system may treat incomplete records as suspicious when the missing information is a predictable result of displacement. A human can hear the explanation and understand that the world has changed. Potentially. Humans are not perfect, but they can recognize emerging facts and revise their interpretation through communication. A fixed automated system may continue applying yesterday's pattern to today's reality. Part 18. Human oversight at the decision stage. This brings us to human in the loop. What is the basic idea? A human participates or supervises an automated decision-making process. The person may review the recommendation, approve the final decision, intervene when necessary, or override the system. That sounds reassuring. It can be, but the phrase is often too vague. We must ask what the human can actually do. Let's create a checklist. Does the reviewer have access to the relevant information? Good. Does the reviewer understand how the system reached its output? Does the reviewer have legal training? Does the reviewer have enough time? Can the reviewer request further evidence? Can the reviewer speak to the affected person? Can the reviewer change or reject the system's recommendation? Will the reviewer be penalized for disagreeing with the system? Does the organization record and learn from overrides? Exactly. Those questions determine whether oversight is meaningful. Imagine a caseworker receives 200 algorithmic recommendations per day and has 30 seconds to approve each one. Technically, a human is in the loop, but functionally, the person may be a rubber stamp, especially if the interface presents the system's recommendation as authoritative. Yes, humans are vulnerable to automation bias, the tendency to trust automated outputs, especially under time pressure or when the technology appears sophisticated. The reviewer may think, the computer has analyzed thousands of variables. Who am I to disagree? Exactly. Meaningful oversight requires agency. The human must understand that disagreement is permitted and sometimes required.
Part 19. Oversight is more than error detection. Many discussions describe the human reviewer as someone who checks whether the system made a technical mistake, but the chapter expects more.
Much more. A proportionality reviewer is not merely checking whether the data was entered correctly. The reviewer may need to identify that the legally correct general rule produces an excessive result in the individual case.
That is a subtle distinction.
Very subtle. Suppose the system correctly determines that a person violated a reporting requirement. There is no factual error. The proportionality question concerns the consequence. Should the violation lead to a warning, a small reduction, a temporary suspension, or a complete termination of benefits?
The algorithm may be correct about the violation and still recommend a disproportionate response.
Exactly. That is why output accuracy is not the same as legal proportionality.
A high-performing classifier cannot answer the whole legal question.
Correct. It may classify facts accurately, while the institutional response remains unjustified. Part 20. The resources required for meaningful oversight.
What conditions do human reviewers need?
At minimum, access to complete and relevant information, authority to intervene, adequate legal and technical training, sufficient time, manageable workloads, clear escalation procedures, organizational protection for disagreement, and records explaining both the automated recommendation and the final human decision.
This creates a paradox.
Governments automate to reduce human effort, but meaningful proportionality review may require substantial human resources. Exactly. That is one of the chapter's most important practical insights. If a system processes 10 times more cases, but each difficult case requires careful human judgment, the authority must maintain enough skilled people to perform that work.
Otherwise, automation creates volume without creating capacity for justice.
Well said.
Could authorities restrict intensive review to high-risk cases?
Yes, provided the method for identifying high-risk cases is itself reliable and lawful. A tiered system might work. Routine low-impact approvals could be automated. Negative decisions, severe sanctions, unusual cases, contested facts, and rights-sensitive cases could receive mandatory human review. That reflects a risk-based approach. Yes, but the authority must continuously test whether the routing mechanism is missing vulnerable cases. Part 21. Stage 4. Ex post proportionality.
The fourth stage is ex post review.
Correct. Ex post means after the initial decision. This includes mechanisms such as internal administrative review, supervisory authorities, ombuds institutions, independent complaint bodies, and court appeals.
What is their role?
They correct errors, review legality, examine proportionality, provide remedies, and sometimes establish standards for future cases.
Could a court review all 4 stages?
Potentially, yes. A court may ask, was the legislation itself proportionate? Was the system lawfully designed? Was the decision proportionate in the individual case? Were adequate safeguards and review procedures available?
So one appeal can reveal a systemic problem.
Exactly. Suppose dozens of people are denied childcare benefits because the system incorrectly interprets a shared bank account as evidence of undeclared household income. A court reviewing one person's case may discover a design flaw affecting thousands.
That is the strength of ex post review.
Yes, but it also has serious limitations. Part 22. Why appeals are not enough.
What is the main limitation?
Ex post review often depends on the affected person taking action. The person must realise that the decision may be wrong, understand the procedure, meet the deadline, obtain evidence, perhaps find legal assistance, and sustain the emotional and financial cost of challenging the state.
Those most harmed by automated administration may be least able to appeal.
Exactly. A person facing poverty, disability, language barriers, insecure immigration status, illness, or digital exclusion may not be able to contest the decision.
And by the time the appeal succeeds, the harm may have already occurred.
Yes, a family may lose housing, a person may go without medication, a business may close, an applicant may miss an educational opportunity. A later correction does not always undo the damage.
So a system cannot rely on the logic, we will automate everything now and correct mistakes when people complain.
That would shift too much responsibility onto citizens and worsen the power imbalance between the individual and the state.
Ex post review is necessary but insufficient.
Precisely. Part 23. Why the location of proportionality matters.
We now have 4 stages. Could one strong stage compensate for weak safeguards elsewhere?
Only partly. Strong legislation can reduce risks, but it cannot foresee every individual case. Good system design can operationalize safeguards, but it cannot resolve every contextual question. Human review can protect individual cases, but reviewers may lack time, information, or authority. Appeals can correct errors, but only after harm and only when people can challenge decisions.
So proportionality should be protected throughout the entire chain.
Exactly. Think of it as defense in depth.
That's a cybersecurity term.
Yes, and it's useful here. We should not rely on one safeguard. At the legislative stage, define lawful purposes and limits. At the system stage, implement privacy, fairness, transparency, and escalation mechanisms. At the decision stage, preserve contextual judgment. At the ex post stage, provide accessible and effective remedies.
Each layer catches different kinds of failure.
Correct.
So could some decisions be fully automated?
Certainly. The argument is not that all public automation is unlawful or undesirable. Straightforward, low-impact, rule-bound decisions may be suitable for automation.
For example, automatically calculating a standard payment after all eligibility conditions have been clearly verified.
Yes, especially when the outcome benefits the individual and there is little uncertainty. But the stronger the impact on rights, the greater the contextual complexity, and the more severe the possible harm, the stronger the case for human involvement and multi-stage safeguards.
Part 24. 3 extended case studies. Case study 1. Automated welfare fraud detection.
Let's consolidate everything through 3 extended examples. First, welfare fraud detection. A government wants to reduce fraudulent claims. It creates a system combining tax data, address records, family relationships, property information, and prior investigations. The system gives every recipient a fraud risk score.
Where do we begin?
At the legislative stage. Is fraud prevention a legitimate aim? Yes, but lawmakers must ask whether mass risk scoring is a suitable and necessary way to achieve it. They must define what data may be used, how risk scores affect individuals, and what safeguards are required.
What might go wrong at the system stage?
Historical investigation data may reflect biased enforcement. The system may use proxies for nationality, ethnicity, poverty, or family status. It may process excessive data. It may be difficult to explain. It may assign high scores to normal behaviour, such as moving frequently or sharing accommodation.
At the decision stage,
A risk score should not automatically become a finding of fraud. A human investigator should examine evidence, hear the person's explanation, and distinguish unusual circumstances from deception.
at the ex post stage,
The individual needs an accessible right to challenge the decision. An independent body should also monitor patterns, because relying only on individual appeals may fail to reveal widespread discrimination.
Case study 2. Automated immigration decisions.
Second case, immigration. A country uses an AI system to assess visa applications. It considers travel history, income, employment, previous refusals, document consistency, and statistical overstay patterns.
This is a high-impact context involving movement, family life, work, education, and sometimes safety.
At the legislative stage, the state must provide a clear legal basis and define the system's permissible role.
What would be a dangerous feature?
Nationality-based historical overstay rates could cause applicants to be treated primarily as members of a statistical group rather than as individuals.
The model might say applicants from country X have a higher average overstay rate.
But an individual applicant may have a stable job, family commitments, a clear travel purpose, and a strong record of compliance. Group correlation doesn't settle the individual legal question.
At the decision stage, the person needs individualized consideration.
Exactly, especially when refusal significantly affects family unity, education, or employment. The authority must be able to explain the actual reasons and allow relevant evidence to be considered.
What about generative AI summarizing the application for the officer?
That could save time, but introduces risks. The model may omit favourable facts, overemphasize inconsistencies, or hallucinate information. The officer must have access to the original documents and remain responsible for the legal decision.
Case Study 3. Automated Public School Discipline. Third case, Public School Discipline. A school district uses software to detect behavioral risk from attendance, grades, disciplinary records, online activity on school devices, and teacher reports. Students classified as high risk receive increased monitoring or automatic restrictions.
The legitimate aims may include safety and student support, but the system could easily confuse disadvantage with dangerousness.
A student with low attendance may be caring for a sick parent.
A decline in grades may reflect depression, housing instability, or language barriers. Monitoring school device activity may interfere with privacy and freedom of expression.
What would necessity require?
The district should ask whether less intrusive support measures are available. Could counselors speak with students? Could teachers make referrals based on observed needs? Could the system be limited to identifying students who may need assistance rather than imposing sanctions?
That changes the purpose from punishment to support.
Exactly. System purpose matters enormously. A risk score used to offer voluntary counseling is different from the same score used to suspend a student.
Same prediction, different legal and ethical consequences.
Correct. A model cannot be evaluated separately from the institutional action attached to its output.
Part 25. Misunderstandings to avoid. Let's address some common misunderstandings. Misunderstanding number 1, humans are biased, so algorithms are automatically fairer.
False. Algorithms may reduce certain individual inconsistencies while reproducing historical, institutional, or design-based biases. The correct question is not human or machine in the abstract. It is which decision structure, with which safeguards, performs better for this specific legal task.
Misunderstanding number 2, if the model is accurate, the decision is lawful.
Also false. Predictive accuracy does not establish legal relevance, necessity, fairness, or proportionality.
Misunderstanding number 3, a human approved the output, so meaningful oversight existed.
False again. Approval may be symbolic if the person lacks information, time, authority, training, or genuine independence.
Misunderstanding number 4, citizens can appeal, so automation risks are adequately controlled.
No. Appeals are essential, but they are reactive, unequal in accessibility, and incapable of preventing every harm.
Misunderstanding number 5, proportionality means balancing everything according to personal opinion.
No. Proportionality is structured legal reasoning. It requires a legitimate aim, evidence of suitability, examination of less restrictive alternatives, and a reasoned balance grounded in the relevant legal framework. It does not eliminate disagreement, but it disciplines the decision-maker's justification.
Part 26, Lessons for AI Engineers. What should engineers take from this chapter?
First, do not assume that a legal rule is fully captured by the variables in a database. Second, distinguish prediction from decision. Third, identify where the law requires contextual judgment. Fourth, design escalation paths for exceptional and uncertain cases. Fifth, preserve enough information for review and explanation. Sixth, do not silently resolve legal discretion through technical defaults.
What would a good design meeting sound like?
Instead of asking only, what model gives us the highest accuracy, the team should also ask, what legal decision are we supporting? Which facts are legally relevant? What kinds of exceptional cases exist? What happens when data is missing? What rights may be affected? Which errors are most harmful? Who can override the output? How will affected people contest it? How do we know when the model is no longer appropriate?
So the engineering specification should include legal and institutional requirements, not just performance metrics.
Exactly.
And what should lawyers learn?
Lawyers should understand that automation is not merely a tool applied after the law is written. Technical architecture can shape how law is interpreted and applied. Lawyers therefore need to engage with data structures, model objectives, proxies, thresholds, error distributions, interface design, workflow constraints, and audit logs.
A legal safeguard that exists only in a policy document may be useless if the software cannot implement it.
Exactly. Suppose the law requires consideration of exceptional hardship, but the application form contains no field where the applicant can describe hardship. The right exists on paper, but disappears in the digital process.
That is a powerful example of law being lost in interface design.
Yes, legal rights must survive translation into forms, code, databases, and organizational procedures.
Part 28, Proportionality by Design. Could we speak of proportionality by design, similar to privacy by design?
Yes, as an analytical idea. It would mean building the conditions for proportional decisions into the system lifecycle.
What might that include?
Before deployment, assess whether automation is justified, identify rights and interests affected, examine less intrusive alternatives, map relevant discretionary spaces, anticipate hard cases, and define human review requirements. During design, minimize data, avoid unlawful proxies, test different groups, document assumptions, preserve explanations, provide override mechanisms, and design for contestability. During operation, monitor errors and disparities, review overrides, update the system when circumstances change, ensure reviewers have sufficient resources, and suspend the system when risks become unacceptable. After decisions, provide accessible explanations, support corrections and appeals, analyze complaint patterns, and feed lessons back into legislation and system design.
That makes proportionality a life cycle responsibility.
Exactly, not a final checkbox.
Part 30, The efficiency paradox. I want to return to the efficiency paradox. Automation promises faster and cheaper administration, but proportionality demands contextual judgment, human capacity, and multiple safeguards. Does that mean legally responsible automation may deliver less efficiency than governments expect?
Sometimes yes. The promise of automation is often based on an unrealistic comparison. A fully automated ideal system is compared to an expensive human administration. But once we add lawful design, data governance, audits, explanations, human review, complaint handling, system maintenance, and correction of errors, the cost picture changes.
That does not mean automation is never worthwhile.
No, it means we need honest accounting. Efficiency gains should not be calculated by ignoring the cost of protecting rights.
And efficiency itself is not the only public value.
Exactly. Public administration also serves legality, equality, dignity, fairness, participation, transparency, and trust. The cheapest decision is not necessarily the best public decision.
Part 31. A practical evaluation framework. Before we conclude, can we offer listeners a practical framework for evaluating an automated public decision system?
Certainly. Let's organize it around 10 questions.
Question 1. What exact public decision is being automated or supported?
Question 2. What is the legitimate objective?
Question 3. Is there evidence that the system is suitable for achieving that objective?
Question 4. Could a less intrusive or less automated alternative achieve a comparable result?
Question 5. Which rights, interests, and groups may be affected?
Question 6. Which parts of the legal decision require discretion or contextual judgment?
Question 7. How does the system identify uncertainty, exceptions, and hard cases?
Question 8. Do human reviewers have information, authority, training, time, and independence?
Question 9. Can affected people understand, correct, and contest decisions?
Question 10. How are problems discovered at the decision or appeal stage fed back into legislation and system design?
That last question closes the loop.
Yes, governance should be iterative. A disproportionate outcome is not merely an isolated failure to correct. It may reveal a defective rule, proxy, threshold, workflow, or institutional assumption.
Final summary. Let's summarize what we have learned. Administrative discretion is the legally permitted space in which public decision-makers interpret rules, evaluate circumstances, and choose between possible actions.
Discretion creates risks of inconsistency, delay, prejudice, and arbitrariness, but it can also protect individuals from rigid and unreasonable outcomes.
Automation can improve speed, consistency, predictability, and scale, but it can reduce the contextual judgment needed for exceptional or rights-sensitive cases.
Proportionality requires public power to maintain a justified relationship between means and ends. It commonly asks whether a measure serves a legitimate aim, is suitable, is necessary, and strikes a fair balance.
Proportionality cannot be treated as a simple mathematical formula. It involves evidence, legal reasoning, interpretation, contextual awareness, and justification.
Discretion and proportionality are connected but distinct. Discretion enables contextual choice. Proportionality requires and limits that choice.
Proportionality must be protected at 4 stages: the legislative stage, the system implementation stage, the individual decision stage, and the ex-post review stage.
No single stage is sufficient. General legislation cannot predict every case. Good system design cannot resolve every contextual problem. Human review can fail without proper conditions. Appeals cannot prevent all harms and may be inaccessible to vulnerable people.
Keeping a human in the loop is therefore not a magic solution.
The human must be meaningfully empowered. That person needs access to information, legal and technical understanding, time, authority, and the practical ability to question or override the system.
The central lesson is not that public administration must choose between humans and machines.
The real task is to design institutions in which automation and human judgment perform appropriate roles, while the entire decision-making chain remains constrained by law.
And perhaps the most important question is not, can this decision be automated?
But can this decision be automated in a way that preserves proportionality, accountability, and the humanity of law?
That is all for today's episode of When Algorithms Govern. Thank you for listening.
Until next time, keep asking not only what technology can do, but what public power should be allowed to do through technology.
Goodbye.
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 Before we finish completely, Daniel, I would like to do a short review exercise for listeners who are using this podcast to improve both their legal knowledge and their English. Great idea.
I'll give you a statement, and you tell me whether it is correct. Statement 1. Administrative discretion means that public officials are free to do whatever they personally consider fair.
Incorrect. Administrative discretion is legally structured and limited. Officials must act within their authority, pursue relevant purposes, consider appropriate factors, and avoid arbitrary or disproportionate outcomes.
Statement 2. An automated system can be consistent but still produce unfair decisions.
Correct. Consistency means applying the same process repeatedly. Fairness may require different treatment when people's legally relevant circumstances differ.
Statement 3. If a measure has a legitimate aim, it is proportionate.
Incorrect. A legitimate aim is only the beginning. The measure must also be suitable, necessary, and appropriately balanced against its negative effects.
Statement 4. A system with high predictive accuracy is necessarily lawful.
Incorrect. Lawfulness depends on legal authority, purpose, data use, discrimination risks, procedural safeguards, proportionality, and other requirements, not accuracy alone.
Statement 5. Human oversight is meaningful whenever a person clicks the final approval button.
Incorrect. The human must have genuine capacity to understand, evaluate, question, and override the system.
Statement 6. Appeal procedures are important, but they cannot replace safeguards before and during decision-making.
Correct. Appeals are reactive and depend on citizens' ability to challenge decisions. Proportionality should be protected at every stage.
Final statement. The goal of proportionality is to eliminate all discretion.
Incorrect. Proportionality structures and limits discretion. In some cases, it may even require discretion so that a decision-maker can avoid an excessively rigid result.
Key expressions for learners.
Let's finish with some useful expressions from today's discussion. The first is, to exercise discretion. For example, the public authority must exercise its discretion in accordance with the principle of proportionality.
Next, to strike a fair balance. For example, the regulation must strike a fair balance between fraud prevention and the protection of personal data.
Another important expression is, to pursue a legitimate aim. For example, although the measure pursues a legitimate aim, it may still be unnecessarily intrusive. Next, a less restrictive alternative. For example, the authority should consider whether a less restrictive alternative could achieve the same objective. Another one, to take individual circumstances into account. For example, automated decision-making systems may fail to take individual circumstances into account. Next, to provide meaningful human oversight. For example, public authorities must provide meaningful human oversight rather than symbolic human approval. Another useful expression, to depart from the general rule. For example, exceptional hardship may justify departing from the general rule. Next, to challenge an automated decision. For example, citizens must have an effective opportunity to challenge an automated decision. And finally, to safeguard against arbitrary power. For example, proportionality helps safeguard individuals against the arbitrary exercise of public power.
Try using these expressions to describe a real or imagined automated system in your own country.
For example, the tax authority pursues the legitimate aim of preventing fraud, but it should take individual circumstances into account and provide meaningful human oversight before imposing a serious penalty.
That is a perfect sentence to end on. Thanks again for listening. Goodbye, everyone.